The subcommittee will come to order. I welcome everyone here today to the legislative hearing on the bill I've introduced, H.R. 1461, the Veterans, Employees, and Taxpayers Protection Act of 2017, or the Vet Protection Act. Before I recognize my friend and fellow Texan, Mr. Beto O'Rourke, for his opening comments, I want to briefly describe what the bill does and provide some context for its introduction. At the joint hearing this subcommittee had with the Subcommittee on Government Operations of the Committee on Oversight and Government Reform, we learned in great detail about the use of official time within the Department of Veterans Affairs. At our hearing, GAO released their recent report on official time at VA, where they found that VA is still not accurately or sufficiently tracking how much time employees are using on official time, and that the data that we do have from the VA is unreliable at best. As I said at that hearing, this report begs the question, are people taking advantage of the system? And I would conclude that most likely they are, because whether intentional or not, without a functioning system, there is no means, consistent means, to track official time even if you wanted to. That's why my bill would require the VA to consistently track the use of official time and submit a report to Congress and the Office of Personnel Management on its use. To address the issue raised by GAO report, this reporting requirement would also bar VA from using ranges or estimates in their reporting. I think this provision and this change are critically important because, as the old saying goes, you can't manage what you can't measure. Another issue that was highlighted in our joint hearing was the amount of time that doctors, nurses, clinicians, and other employees who are critical to VA's mission are spending on official time and union activities, as opposed to the job they were hired to do and the job that they are being paid to do by taxpayers. We learned that VA has doctors, nurses, medical assistants, addiction therapists, pharmacists, disability claims raters, senior raters, and the list goes on, serving on official time, many of them on 100% of official time, and many making over six figures, which is paid for, again, by the American taxpayer. This means we have hundreds, if not thousands, of VA employees spending part, and sometimes all, of their working days serving the union instead of directly serving our veterans. Again, the job that they were hired to do. My bill would address this problem by prohibiting VA physicians, dentists, podiatrists, chiropractors, or optometrists from spending any of their time on union activities. It would prohibit any employee involved with direct patient care from spending more than 25% of their time on union activities, and it would prohibit any VA employee from spending more than 50% of their time on union activities. Furthermore, the bill would prohibit the use of official time for political activities or lobbying. Now, I want to be clear, these provisions are not meant to completely eliminate the use of official time at the VA, as the amount of allotted hours in a union's official time bank would not change, but instead this bill would bring common sense reforms to the use of official time and would ensure that those who are charged with providing care and services to veterans are fulfilling the VA's mission and doing their jobs. As I said at our hearing last month, the legal standard for official time is to use it on, quote, representational work. That is, quote, reasonable, necessary, and in the public's best interest. That is at the heart of the issue for me today in our discussions. I don't believe the average American would see doctors and nurses receiving a taxpayer-funded salary, especially with the context of our veterans and the current service to our veterans from the VA, as reasonable or as being in the public's interest. Additionally, my bill would allow collective bargaining unit employees to join or leave the union at any point. Currently, collective bargaining agreements at the VA seem to be designed to make it nearly impossible for employees to stop paying union dues and nearly impossible to leave the union when they choose. For example, the VA's master contract with AFGE requires that the only time an employee can make a request to stop paying dues is during the 10-day period that annually coincides with them joining the union. VA's master contract with the National Nurses United goes a step further and limits their window to leave the union to the anniversary of their decision to join the union. Clearly, these restrictions are in place to do one thing and one thing only: limit the employee's freedom of choice. We'll make it two things, and generate revenue for the union. Finally, my bill would extend the probationary period for new employees to 18 months and would require that the manager make an affirmative decision that the employee has successfully completed their probationary period before becoming a full-fledged civil servant with all of its protections. Members, I know many will say that my bill is anti-union or even anti-employee. Nothing could be further from the truth, as I do see that there is limited value in what the unions bring to the table. And I'm not here to litigate the ability for federal employees to unionize. I am, however, trying to restore public confidence in the Department of the Veterans Affairs by ensuring that taxpayer dollars and hardworking Americans, or of hardworking Americans, are focused on advancing the VA's mission. In the end, the VA and the status quo are not sacred, but our veterans are. I thank the witnesses for being here this afternoon. I look forward to your testimony, and now I want to yield 5 minutes to my friend, fellow Texan, and ranking member, Mr. O'Rourke.
Mr. Chairman, thank you. I think the bottom line for me, and I would argue for us as members of this committee and members of the U.S. Congress, is to ensure the highest quality and timeliness in the care and services that we deliver to the veterans who have earned that care and services. If official time improves our ability to do that, then we should have official time. If it detracts from our ability to do that, we should not have official time. If we conclude that official time helps us to deliver quality care and services to veterans, then I think we have to ask ourselves, what is the best way to organize that official time? And if we conclude that in some cases, having 100% of an employee's day dedicated to official time because it improves the delivery of care and services to veterans is helpful, then we'll support that, or I will support that. If we find that it does not, then I will not support 100% of official time. And then the third category that the chairman mentioned, if we conclude that certain classes of VA employees should be able to participate in official time, and that it is helpful in delivering care and services in a timely, quality way, then we should support that. And if we conclude that it does not, then we should not. I think we need the data and the facts to make informed decisions in every one of these areas. And so I agree with the chairman, and I think with probably everyone on this committee, that the VA's failure to measure official time effectively has put us at a disadvantage in answering these questions. And that's one of the first things that we need to be able to do, which is to measure. That which is not measured cannot be improved, and we can't make informed decisions without it. It's going to be hard for me to conclude beyond that the value in these areas until we have the data and the facts. But I look forward to the testimony from this panel, and we'll reserve questions until after I hear from them. So, Mr. Chairman, thank you, and I yield back.
Thank you, Mr. O'Rourke. I want to now recognize our first and only panel of witnesses today. With us, we have Ms. Kimberly Perkins McLeod, Acting Executive Director for Labor Management Relations at the U.S. Department of Veterans Affairs, and she is accompanied by Mr. Rondi Way, a Human Resources Policy Advisor at the Office of Human Resources and Management at the U.S. Department of Veterans Affairs. Welcome. We also have Ms. Shirley Parker Blommel, President of the Local 390 Unit of the American Federation of Government Employees out of St. Cloud VA Healthcare System, and Mr. Dirk A. Wilcox, a Senior Attorney at the Mackinac Center for Public Policy. I want to thank you all for being here today. Ms. McLeod, let's begin with you. You have 5 minutes for your opening statement.
Thank you. Good afternoon, Mr. Chairman, Ranking Member O'Rourke, and other members of the subcommittee. Thank you for the opportunity to discuss H.R. 1461, entitled the Veterans, Employees, and Taxpayers Protection Act of 2017, which pertains to the use of official time and probationary employees. I'm accompanied today by Rondi Way, Human Resources Policy Advisor in VA's Office of Human Resources and Management. VA generally supports H.R. 1461, but we have some concerns with the legislation. With regard to Section 741, the inclusion of this record-keeping requirement will result in increased cost and resources for the VA. The department currently has the ability to electronically track union official time for employees in the VA Time and Attendance System, or VATAS, and is in the process of fully implementing the system with the projected completion date of July 2018. Using VATAS, the department can now track the categories of official time in accordance with OPM's 4 categories: term negotiations, midterm negotiations, general labor management relations, and dispute resolution, similar to the way all other agencies track official time across the federal government. However, Section 741 would require the capture of additional information regarding official time, which would require a revision to VATAS, as well as the use of additional systems resulting in additional costs in order to capture the monetary and space aspects of the bill. Section 741 also calls for the collection and analysis of subjective data, requiring VA to determine the impact that granted official time has on its operations. Overall, to maintain the tracking and reporting of this administrative data to the level of granularity required in this bill, VA would be required to create additional systems at significant cost. To reduce the cost burden, we ask that the committee reconsider some of the granular reporting requirements in the bill, and we would welcome the opportunity to work with the committee to alleviate these concerns while achieving the important objective of increased transparency. With respect to Section 742, VA does not oppose the time limitations established in the legislation. However, VA finds certain lobbying activities on behalf of VA beneficial to VA stakeholders, the veterans. Indeed, veterans have benefited from union lobbying efforts in areas such as expansions of scopes of practice for nurses and pay and hiring flexibilities to provide expedited patient care. The department is also generally in favor of the types of limitations on the use of official time for certain individuals set out in Section 742. We would prefer that doctors spend all their work time caring for veterans. In addition, we think it is important for every employee to spend at least half of their work time performing management-directed tasks. Currently, however, the law does not allow us to limit official time to particular employees or classes of employees. If this bill passes Congress and becomes law, VA will have that capability. VA also notes that, unless otherwise superseded by Section 742, the provisions in 5 U.S.C. 7131 continue to apply to certain mandatory official time. To the extent the intent is to supersede that provision, VA recommends clarifying language in Section 742. We would be happy to work with the committee on this language. VA does not have a position with regard to Section 743. However, we propose that the bill include clarifying language regarding what termination means in the context of the bill. VA recommends that the term termination be clarified to mean the submission of an employee's SF-1188 to his or her servicing HR or payroll office. With regard to Section 719, VA does not oppose this provision. We note that under 5 U.S.C. 7511, certain VA probationary employees are already entitled to appeal a separation action to the Merit Systems Protection Board if they have worked for the federal government for more than 12 months. The 18-month probationary period prescribed by this bill would not change this right. Consequently, to the extent that the intent is to curtail appeal rights during the probationary period, relevant changes should also be made to 5 U.S.C. 7511. VA would be happy to work with the committee on this language. Mr. Chairman, this concludes my statement. VA looks forward to working with the committee to provide technical guidance on those elements we have noted may be of concern. I'm happy to answer your questions.
Before we move to the next panelist, if you would indulge me, I failed to recognize the ranking member of the VA committee, Mr. Walls. Thank you for joining us today, and I want to yield as much time as you need to make comments. Are you sure? Okay. Thanks for joining us again, and let's continue on with our panelists, Ms. Parker Blommel. You have 5 minutes.
Thank you. Chairman Arrington, Ranking Member O'Rourke, and members of the subcommittee, thank you for the opportunity to testify today. I come to work at the St. Cloud VA as an LPN in 2008 after working at several different private practices in rural and urban areas. I was elected president of Local 390 in 2014 and vice president in 2012. Our bargaining unit covers a wide range of positions, including housekeepers, doctors, food service workers, therapists at the St. Cloud VA main campus, and the CBOCs. After 1 year at the St. Cloud VA as a nurse working on the floor, I signed up to be a union member, went to meetings, and learned that I could make a difference. Also, my father and son have served our country overseas in the Army, and I want to give back for all that they have sacrificed. I realized that getting involved with AFGE, I could help the frontline employees learn how to work with management to improve veteran experience. Being a local officer has been very fulfilling for me and has taught me it's not about the union is right and management is wrong, but rather that we have a shared goal in improving care, and when the union and management work together, we can move towards the same positive outcome. When I first came as vice president of the union, I was only on 50% official time. As the need increased for us to be present, management frequently pulled me from my regular duties. After I was elected local president, it was clear that management's expectation was the president would be working only administrative hours. Management likes the continuity of having me work 100% official time, so I am available when they call a meeting, schedule a grievance hearing, or when they have an employee crisis. In 2015, veterans employees went outside to complain about the lack of providers and the increased primary care panels. Congressman Wallace and Emmer came to our facility after the union contacted them. The union coordinated a meeting with the congressman and the employees where they could share their concerns without fear of retaliation. After mediation, we now have a leadership in our facility who is willing to work closely with the union to address the issues. Another example is when OSHA inspectors came to our facility in 2013 and found a long list of violations. For instance, when staff did not always have the right equipment to avoid blood-borne injuries when handling sharps. As a union representative, I worked with OSHA and management to ensure the violations were corrected and made sure staff had the correct training. So our environment is safer for our employees, also so our veterans we serve. Every day I go to bat to work for our employees to resolve differences with management as quickly as possible. 100% of our housekeepers are combat veterans, and they play a critical role in patient care by keeping operating rooms and other areas free of infection. Many of these veterans suffer from other combat-related injuries. When these veterans came to the union for help, we explained their rights under Family Medical Leave Act, and we reach out to management to soothe the tensions that ask for greater understanding. These employees are combat veterans who are America's heroes. They deserve a job, and they deserve to be treated with dignity. My final example was just recently a new directive on query state prescription drug monitoring program that came out. This has a big impact on the working conditions. Providers will have to begin to query when veterans get narcotics or change in prescriptions. The union worked with management to determine which positions are best suited to assist with the queries. We also need to continue to work together to make sure providers understand who should be delegated this task and the process that needs to be completed. If H.R. 1461 were to become law, I would only be able to spend a quarter time fulfilling my duty of fair representation. The knowledge base and effectiveness would be different depending on who was on official time that day. There would be no consistency. This would have an adverse impact on our veterans, our employees, and as well as management. We achieve more consistency and efficiency when labor and management are working with the same knowledge base among individuals. It is faster, smoother process when we have one person working full-time on representation rather than 4 people at 25%. If we don't have the right person at the table who can actually make the binding decisions, then everything will get deplayed. This concludes my statement, and I'd be happy to answer any questions you have.
Thank you, Ms. Parker-Blommel. And finally, Mr. Wilcox. We'll now recognize you for 5 minutes.
Good afternoon, Chairman Arrington, Ranking Member O'Rourke, and members of the committee. Thank you for holding this hearing and giving me an opportunity to discuss this issue of the use of official time at the Department of Veterans Affairs. My name is Derek Wilcox. I'm the senior attorney at the Mackinac Center for Public Policy. The Mackinac Center is a nonpartisan research and educational institute dedicated to improving the quality of life by promoting sound solutions to public policy questions. I'd like to note that as a practicing attorney, I've had the honor of representing many veterans as their court-appointed counsel in mental health, guardianship, and conservatorship hearings. I've spent many hours at the VA facility in Ann Arbor, Michigan, working with the staff and veterans there. The VA hospitals are beset with many problems as they try to meet the needs of our veterans, and official time is added to those problems. Official time is time spent by federal employees who are paid to perform representational work for their union instead of their regularly assigned work. In the recent past, this body has heard testimony from the Office of Personnel Management, estimated that in 2012, the most recent year for which data is available, employees at the VA used just over 1 million hours on official time. The estimated cost to the VA was just under $47 million. The GAO has criticized the OPM's method of accounting, saying that it undercounts the amount of salaries devoted to official time. Testimony before this committee on February 16, 2017, also criticized the OPM methodology because it failed to account for office space, equipment, phones, travel time, and other factors. But what the GAO did not look at is whether or not the official timekeeping itself is flawed. From my investigations, it appears that use of official time is underreported. I examined cases brought before both the Department of Labor's Employees Compensation Appeals Board and the Federal Labor Relations Authority. These cases involved the use of official time by VA employees, and official time was a central part of these cases. In so doing, I found several cases where more time was devoted to the union's activities than had been reported as official time, as set forth in my written statement. Perhaps the most egregious was a FLRA case out of the Medical Center at Leeds, Massachusetts. A clinical neuropsychologist was also the union president. She was allowed to spend 60% of her work week on official time. However, an arbitrator found that because of her official time, it was an unfair labor practice to require her, as part of her performance appraisal plan, to see any patients per week because, quote, official union duties placed time constraints on the grievance clinical schedule during the work week, unquote. It was unfair to require her to see as few as one patient for testing per week. In short, what was recorded as 60% official time effectively became 100% official time. The enactment of H.R. 1461 could provide the necessary tool to properly count the hours and total cost of official time at the VA. Likewise, it would restrict official time activities so that physicians, like the psychiatrist in the case above at the Leeds facility, are using their skills and expertise on the treatment for which they are trained and hired and not for union activities. Section 741A's requirement that time be accounted for accurately and to a specific degree should eliminate the case of duty time being used for union activities outside of official time, as the aforementioned cases found. Section 7412E and F should correct the flaws pointed out in the February 16th CEI testimony before this body, which pointed out that official time was not accounting for fringe benefits, office space, or other facilities used for official time. Section 742A correctly restricts official time for being used for political activities or activities related to lobbying. In summary, when cases have been looked at in depth, it has been shown that employees have been using more time for union activities than has been allocated to them as official time. H.R. 1461 would appear to be a necessary first step to properly track how much time VA employees spend on official time, account for the true costs, and restrict the improper uses of official time. Following the enactment of H.R. 1461, we should get a more complete picture of the extent of the problem and better enable managers to effectively use the resources available to help our veterans. I'd like to thank this subcommittee for this opportunity and will welcome any questions.
Thank you, Mr. Wilcox. I now will yield myself 5 minutes for questions. And let me start by saying that I think we would all agree that the most important asset to the VA and its accomplishing its mission to serve veterans, like most organizations, would be its people. And I've been in management positions. I've managed in government. I've managed in the private sector. And I can't imagine that you could effectively manage your personnel assets when you have people that are spending 100% of their time on union activities, or even 50% of their time on union activities. And I agree with the ranking member that, our job is to make sure that you guys have the tools, and the VA leadership has the tools to maximize their effectiveness, and that where there are distractions, we need to root them out, because we all want desperately to make good on our promises to our veterans. So with that, let me ask you, Ms. Parker Brommel, Brommel Parker. I apologize. What is the mission of the VA? Just in your own words. I'm not looking for the textbook answer.
The mission of the VA is to serve our veterans.
Yeah, hit the button. There you go.
The vision of the VA is to serve our veterans. They are our heroes. They have sacrificed their lives for us.
And then your job, when you applied for the job and you interviewed for the job and ultimately got the job, what is the mission of your job specifically to advance that overarching goal of serving our veterans?
When I was hired for the VA, I am a licensed practical nurse. I have been there 9 years. And my mission is to take care of our veterans, to honor them for the sacrifice, to take care of them physically and mentally, however it needs to be done.
So the three-part legal test, as I understand it, for appropriate use of official time is that it's necessary, reasonable, and in the public's best interest. You were hired to provide health care services to veterans, to advance the overall mission to serve veterans. How can you spend 100% of your time, and with all due respect, I know there are more people that are spending 100% of their time than you, but give me your perspective on how you can achieve that desired outcome you described as your mission and that which you were paid to do by taxpayers while you're 100% active on official time advancing union objectives.
Being under 100% time, what I do, I take care of our veterans. First of all, when a directive or a policy comes forward, we have the opportunity to look at that and see what work needs to be done. I take the policy, I look at it, I go to the frontline staff, and I say, this is the policy that's coming out. How can we do this? How can we make this work the best? Because they're the subject matter experts. And I get that information, and I go back to the meeting or the committee and say, this is what's going on. This is what's happening. How can we do it better? We got this directive from the VA. Let's make it right.
Ms. McLeod, we put a standard in the legislation of no more than 50% of their time. Do you have managers express their frustration with their ability to manage their operation, whatever component of the VA, on account of this runaway use of official time?
Certainly, we've had managers who've expressed frustration with, official time. We've also certainly had managers, in the GAO report notes, we've had managers who appreciate certain employees being on official time for the reasons that witness discussed. So we do see both sides.
Let me ask you, is it necessary for employees to spend 100% of their time? Is it absolutely necessary for employees to spend 100% of their time on union activities?
The department does not think so. We support the legislation.
Do you believe it's necessary to spend 50% of your time? Is it necessary to spend 50% of your time on union activities? It's my last question. I'll let you answer.
Well, the department supports the legislation, and so to the extent the legislation caps or limits it to 50%, no more than 50%, the department supports that, and we don't believe that any time over 50% would be reasonable, necessary, or in the public's interest.
Okay. I yield to the ranking member for 5 minutes for questions.
Great. Thanks, Mr. Chairman. I ask unanimous consent to submit 2 letters, one from National Nurses United, dated March 20th, 2017, and the other from Michelle Washington, PhD psychologist, AFGE member.
Without objection.
Great. Couple of questions here. First, some observations. I heard Ms. McLeod acknowledge the value of official time, and she even went further and talked about the value of bargaining unit employees using official time to lobby members of Congress. And you cited helping to inform members of Congress about expanding scope of practice and helping to inform members of Congress about the value of flexibilities in hiring at a time that we're 43,000 clinical positions short, and we desperately need those providers, psychologists, and psychiatrists primarily in communities like El Paso, Texas. So I appreciate you from the VA underscoring the importance. Answer this question for me. When we hear from our AFGE president in St. Cloud that the expectation was that from management that she always be available to expedite the process to better serve veterans and ensure that management is effectively coordinating with the employees who serve those veterans. What's your argument against 100%? That's management asking for 100%, not AFGE. And so what's your argument as somebody who oversees management?
The department believes that, at certain levels, official time is valuable, and so.
But I'm asking about 100%, so answer that question for me, please.
I mean, I think to the extent that the department or her management is requesting her assistance to perform official time or union representational activities, that local manager knows best, and they're
So that local manager
time.
knows best and is requesting 100% time, and yet you're supporting a cap at 50%. So those two don't seem to match up. So if you see the value and love to give and would like to give discretion to that local manager who understands the value in 100% official time in that VA, why would you support legislation that would remove the ability of that manager to do what's best for the care for those veterans based on coordinating with the employees who deliver it?
I can only say the department supports the legislation and the limitations that are placed.
And then I've got a question on the other side of this from Ms. Blommel, and I want to thank you for traveling here to Washington, D.C. and being before us. I've got to say that, the chairman's argument that when we have a time of clinical positions that are vacant, that, having a doctor at 100% and not having them perform some clinical function is pretty persuasive. Make the argument to me that those primary or those care providers who are on the front lines of delivering that care shouldn't have some part of their day devoted to care delivery.
Most physicians, even if they have administrative jobs, they do have to have so many people on a panel. So most of them are not 100% because they have to care for veterans. The majority why you have a physician that wants to be in the union is because they have a greater understanding of what's happening on that side. And they can bring a wide range of talent and knowledge to the union and for management.
Okay, yeah, and I think you can tell where I'm getting to. I see the value in official time. I see the value in 100% official time, at least as management has conveyed it to us, where they want to more effectively coordinate with the staff that's delivering that care. I also see an argument where we have shortages in clinical positions that you might want to have some controls on that. So I'm trying to find the ideal place for us to be. Going back to Ms. McLeod, 2018 July to get this stuff done is, I mean, we're at the end of this session of Congress by then, functionally. Our ability to conduct oversight on what you've implemented before the next Congress kicks in is gone. Why can't you do that sooner? Why can't we have the information this summer?
The department, we're about 60%, in terms of fully implementing VATAS, and we're moving as quickly as we can, trying to make sure that as we implement, the system is working appropriately and people are trained. Unfortunately, I'm not responsible for making sure that's fully implemented, but we are moving as rapidly.
Who do we talk to if you're not the person responsible? How do I find out how to get that information sooner? It just doesn't seem acceptable to me to wait until July 2018. Otherwise, we're going to move forward with a bill that I think is very well-intentioned from the chairman's standpoint. I think he wants to do the right thing for veterans, but from my standpoint, doesn't have the data or the information to support the conclusion. So, you're not giving me much to work with here. I yield back to the chairman.
Thank you, Ranking Member, and I want to recognize or just acknowledge that the chairman of our VA committee is here as well, but I'm going to yield now questions to Mr. Rutherford. 5 minutes for questions.
Thank you, Mr. Chairman, and I will direct my first question to Ms. Perkins. If you could, in your written statement, it says, currently, however, the Federal Service Labor Management Relations Statute does not allow us to limit official time to particular employees or classes of employees. Can you tell me where that excluding language is within the Federal Service Labor Management Relations document?
You're not going to find it necessarily in the statute, but the Federal Labor Relations Authority that interprets the statute through case law, they have found that we can't limit the employees or the occupations that those employees sit in terms of providing official time.
So there's some finding by them?
There's a number of cases that discuss that you can't limit who those individuals are who serve. Those are elected positions through the union, and that determines, generally speaking, who's on 100% or somewhere near that.
Okay. However, you go on to state also that if this bill passes Congress and becomes law, you would have that ability.
That's correct, sir.
Okay. So we need to make sure that we do put that enabling language in the bill, Mr. Chairman, so that we have that right, or the VA has that right to limit those positions. Next, I'd like to ask Ms. Blummel. Am I saying that right? Thank you. You mentioned that directives that come down, that management or official time is used to help management carry out directives that come down. Can I ask, what does management do then?
What management will do is that they will get the new directive from the VHA, they will read it over, and then they will contact the president of that local, and they will forward the directive to me, and I have the opportunity to read it. We gather at a meeting, and we go through it pretty much line by line of the changes of work condition. Example, as I gave before, was the prescription, is that the physicians now have to query the veterans to make sure that they do that, but they can also select a delegate. The question is, who is the most appropriate delegate? In the directive, it says it could be also a unlicensed person. Our VA does not find that appropriate. We find that having a licensed nurse be the most appropriate. So it was working that out, how this information and how we're going to do it, and how we're going to get the training to the physicians and the correct people. So
are there not VA managers who are making those decisions?
the direct, yes.
I mean, I'm simply trying to find out who's running the VA. Is it union members or is it VA
We have
management?
managers who work for the VA, yes, sir.
Okay, yeah, but is management union members also?
No, sir.
Okay. Thank you, Mr. Chairman. I yield back my time.
Thank you, Mr. Rutherford. And now I will yield 5 minutes to Mr. Takano.
Thank you, Mr. Chairman. Ms. McLeod, H.R. 1461 is predicated on the notion that allowing employees to be on 100% official time is getting in the way of veterans' access to health care. Yet, one of the criticisms of the GAO is, the report, is that the VA itself doesn't really have a firm accounting for official time, right? And because we don't have it, my question is, I don't understand how we can come to the conclusion that official time is impeding or not. I mean, I'm having a hard time how we get to that conclusion. But isn't there, I mean, I have a hard time thinking about the 45,000 current vacant positions at the Veterans Health Administration. I mean, I just think compared to the small number of employees that we have on official time, that the 45,000 vacancies pose a far, far greater, I think, impediment to VH to giving appropriate health care to our veterans. So my thing is, I want to ask you, do you have any idea of how many employees that Ms. Blumel represents in her area?
No, I don't know how many employees she specifically represents. No, I know that approximately 285,000 of our employees are bargaining unit employees, but that's stretched across all of the unions that represent them.
And do you know how many meetings she might attend every day?
I do not.
I mean, might there be a cost savings that accrues by having a professional, by having someone on official time actually try to resolve these disputes than to have someone else do it? I mean, to have to hire extra people to go solve these disputes?
Sir, we haven't looked at the cost-saving aspect of the time that employees spend on official time. I could only give you the numbers themselves, but we've never looked at what the cost effect is of that.
Don't you think we might want to do that before we move forward with a bill that blanketly says that 100% official time is bad without knowing all the facts, without knowing whether or not there might be a cost savings?
I believe a portion of this bill does require us to take a look at some pieces of that, the amount of benefits and costs and salary for each official time employee and what that is for the agency. So we would be looking at that as a part of the reporting requirements.
Well, you know, I'm concerned that with the hiring freeze and the shortages, the attrition rate, the GAO is going to tomorrow testify about the VA's limited HR capacity. Currently, there's a 12% attrition rate at VA's HR workforce that's being caused in part by unmet HR staffing targets, contributing to increased HR workloads and staff burnout. Additionally, HR occupations are not exempt from the hiring freeze, and the GAO believes that a prolonged freeze could further erode the VA's ability to provide HR services. Employees are, on official time, solve workplace disputes and resolve issues between frontline employees. And in light of this shortage and attrition rate, it would seem to me that there's probably even maybe greater demand, but we don't know that because we don't have accurate statistics, or we don't have a study to know whether or not there might be a cost savings, especially in this current environment.
We don't know.
Ms. Blumel, whistleblowers, don't they especially often need people on official time? They're reluctant to come forward without having an official time VA employee be by their side. Isn't that right?
That is correct. A lot of people do come forward. They come to the union because of concerns, and we help direct them to the right way to get that protection of concerns of a veteran or a policy.
So an arbitrary cap at 50% might end up in a result where whistleblowers may not have access to someone who will stand by their side if they're needed.
That is correct. We are very instrumental with the staff. They come to us. A lot of times they'll come to us before going to management because they have concerns and they don't want there to be known that they're coming forward. And we just give them the support to go forward.
Well, thank you. My time is up. Mr. Chairman, I yield back.
Thank you, Mr. Takano. And now I will yield 5 minutes for questions to Mr. Correa.
Thank you, Mr. Chairman. First of all, I want to thank you for bringing forward this piece of legislation. The timing can be better. As I was listening to the testimony of our witnesses, I noticed Ms. Kimberly Perkins McLeod, our acting director, stated she supports the legislation, yet at the same time she had some concerns regarding some definitional issues and other issues in the bill. And I would say, Mr. Chairman, that maybe this legislation might need a little bit of wordsmithing and some work to make sure that what we mean in what we say and what is written is actually consistent, so to speak. Again, the issues you're touching upon here, I believe, are important ones, which are taking care of our veterans, making sure we have an efficiently run VA, and you want to make sure that you reduce the possibility of unintended consequences. Therefore, I would ask you to take heed to Ms. Perkins McLeod's comments, and before we move the legislation forward, I'd ask you to work with some of the witnesses to make sure that this is some legislation that does exactly what you, Mr. Chairman, intended to do. Thank you.
Our ranking member of the VA committee, Mr. Waltz, I yield to you for 5 minutes.
Thank you, Mr. Chairman, and thank you all for being here. I think the first thing is that we're starting out with the assumption that union time is something separate than trying to improve the process for veteran care. That's not the case, and I heard some of the things we're saying, well, if you're lobbying on time, I would argue that Ms. Blummel is here today lobbying, but this is helpful for us to get at the heart of how we fix veterans issues. So it's not always as simple as it's made out to be. And I would ask first to just look at this from this perspective. We're here to serve veterans, and I'm thinking about this as a veteran. The Army and the taxpayers paid me to shoot artillery. That was my job. That's what I should be doing. If I were not shooting artillery, if you were not being an LPN, was I not adding anything to the Army? So what ended up happening was, as I became more efficient at shooting artillery, I ended up being a sergeant major. The management is the officers, and the colonel would give his directive. My job was to go down to make sure all of the other folks firing artillery were able to do so efficiently, safely, and accurately to fulfill their mission. For the last 5 years of my career, although I was supposed to be the best artilleryman in the unit, I never fired artillery. But I made sure all those other people could do it. Without that ability, the colonel would have to come down through the chain of command and go to each of them. And the reason this is an HR perspective is the people that actually have to deliver it will sometimes tell you, sir, with all due respect, this directive will not work and it imperils our patients. So that flow of information back up that's considered union time is trying to figure out better ways, just like sergeant's time, to figure out how to make us more efficient to deliver the care. So the argument that we're making without the data, that we're instantly more efficient without having them there, I think is specious at best. And as you said, you got asked, Ms. McLeod, about how many people Ms. Blummel had. I realize that that is not, and that question is asked to point out, and Mr. Takano is exactly right, that you don't know in that case, nor should you know. It's not to jam you up. It's the question of, even if they could say that she represents 1,600 people, and know how many meetings she had, you're making an arbitrary decision across the spectrum when wouldn't it be best for local management and HR personnel and management to do that? Ms. McLeod?
Sir, I think there's an opportunity here, even with the legislation, for managers to take a look at, what amount of official time is reasonable, necessary, and in the public's interest. I mean, the limitations here are with respect to certain occupations, but it does not completely limit, these individuals' ability to perform union representational activities, and it's still the local manager's responsibility to make that decision.
What if we find out we need more official time?
Sir, there's also, by the way this is written, there's certainly still an opportunity there to provide additional official time to the extent it's reasonable, necessary, and in the public interest.
Ms. Blummel, do you keep track of your official time?
Yes, I do.
How do you do it?
I do it, I have a paper copy that all of my union people that have any time in the union, and we forward that to HR at the end of the month. We do it monthly.
Ms. McLeod, what does VA do with that then? She kept track of it. She wrote it down what she's doing. What do you do with it?
Each of those local HR offices, they provide that information to my office on a yearly basis to Labor Management Relations, and we provide that information back to OPM when they make their data call to all the executive branch agencies.
So it's collated. Whose fault is it if it's not being kept? The idea that we don't know. Would you say it's the employee's fault? Was it Ms. Blummel's fault?
Sir, we keep the information. Now, the way that we've received it in the past has been through different methods, but in large part, we believe that most of the information we have is pretty accurate. We're just going to a new system that will ensure its accuracy.
Okay. Ms. Blummel, have you ever seen anybody abuse official time?
No.
What would you do if they did?
I'm very rigid about the official time. I have had people that I have felt maybe might not have taken their 30 minutes. I will talk to them. I will counsel them. And I've also, with having in regards to maybe if I think it's inappropriate, I will ask them to step down. I have no problem doing that. This is a trust that we have, and we have to honor that.
Am I right that your father and your son are both veterans?
That is correct.
Do you feel like if they came to your hospital that you in your current position would be serving them well with what you're doing, or could you do it better elsewhere?
They would come to our hospital. My father did, and my son is a current at St. Cloud VA.
And you in official time are improving their care in your mind?
Yes, I am, sir.
I yield back.
Thank you, Mr. Ranking Member, and I think we'll go for round two here for anybody that would like to stay and can stay of my colleagues. Let me, I'm thinking as you're commenting on these questions, what it would be like if I brought you to a town hall meeting in Big Spring where they have a large veteran community, they have a VA hospital, and I introduced you as somebody that was paid to be a nurse to provide care for our veterans, but now you're spending 100% of your time on union activities, then I would proceed to say, but wait a minute, before you pick up the rocks, the law allows her to spend some of her time as a VA tax-paid employee on union activity. But it has to be reasonable, it has to be necessary, and in the best interest of the public. What would you say to that group of people if I brought you with me to Big Spring next time I get out in the district about why you do what you do and that it's justified as necessary and reasonable?
Well, I would love to go with you to Big Spring and have that discussion at the town hall. First of all,
Can I hide behind the podium when I ask that question?
sure. One of the reasons, I would really say to that crowd, and I've gone to town halls, is that I am there for them. I may not be doing hands-on directly, but indirectly, I am making sure that they have the best instruments, the best people doing the job. I can help make sure that we have the policies.
Ma'am, how are you advocating for the veterans to make sure they have the best people and the best instruments?
I have the opportunities to go to these meetings. An example, we have.
You know what, I don't have a lot of time here, so what the veterans need is to see a doctor or a nurse or a healthcare professional. They're waiting way too long. I think if you ask the veterans, they'd say, just let me see a healthcare provider because I'm sick. And I don't know that they would say, and I don't believe they would agree, that 100% of your time being spent when you're a healthcare provider on union activity is reasonable, necessary, in the best interest of the public. I don't believe that. I haven't met one, not one, that says that. So how many bargaining unit employees are there at the VA, roughly?
Roughly 285,000.
And it's my understanding that the bank of hours is 4 hours per bargaining unit employee, roughly. Is that correct?
Roughly.
So with all those employees, 285 bargaining unit employees, how can anybody, well, let me just ask the question, just yes or no. With 285,000 employees, do you truly believe, we'll start over here and work our way across, do you believe, Mr. Wilcox, that it's necessary for somebody to spend 100% of their time, that they couldn't possibly spread out 25% among the 285,000 employees. Is that necessary? I would not say it's necessary. Do you believe it's necessary?
Yes, I do.
Ms. McLeod?
No.
With 45,000 vacancies and the stories that are more than disheartening, they're shameful in the wait times and the lack of access to care that our veterans get. Are you telling me that somebody, especially somebody that is in a healthcare provider position, working 100% of their time on union activities is reasonable in the best interest of the public? In that scenario, do you believe it's reasonable and in the best interest of the public?
No, I wouldn't find that to be reasonable or the best interest of the public.
Do you think it's reasonable and in the best interest of the public with 45,000 vacancies, long wait times, and lack of access to care for our veterans that you're spending 100% of your time on union activities?
Yes, I do.
You think it's reasonable?
What I think is reasonable is that I am doing it, and we're not pulling different people from different areas to do it, and then we're disrupting care. I can tell you that what I have just recently done in mental health is where they came up with a policy where they wanted to remove 2 mental health triage nurses and only use 1 and use an LIP, which is a licensed independent provider.
I would feel more honest with the taxpayers if we redefined your position and made you apply for a full-time union advocate position than to do what we're doing here. It doesn't feel right. I'm out of time, so I'm going to yield now to Ranking Member O'Rourke for 5 minutes.
Thank you, Mr. Chairman. I want to make sure that we're being accurate with the words that we're using. To be clear, official time is time that is spent in improving the quality and efficacy and timeliness of care and services to veterans. Union time or union activities are things that help the union, and you can't use official time on behalf of the union. And some folks on the committee have used those 2 phrases interchangeably. They're not the same. And I think we have to start with the fundamental question: is official time valuable for veterans? If it's not, I say let's do away with it now. Let's not even bother with counting it or qualifying it or determining what percentage of which employees can spend on official time. If it's not helpful, let's not do it. But I think that employees who works for the VA agree that official time is valuable. And the VA itself brought forward examples of where official time has improved the quality and timeliness and level of care delivered to veterans. So for me, that question is settled. And when we had our oversight hearing last month, there were other examples given. For example, mental health care treatment regimens that, because of the coordination with AFGE, they were able to add substance abuse counseling. Having just visited Big Spring, and where we have some El Pasoans who are receiving treatment, and seeing the great care that they told me they were receiving themselves from those bargaining unit employees, I'm convinced that there's value and there's efficacy. But to be intellectually honest, I want to make sure that I understand this from a fact-based and data-based perspective. And because the VA has failed in effectively measuring and reporting this back to Congress, we're unable to do effective oversight. And so I ask through Ms. McLeod that someone from the VA who can answer this question and is in charge of this come before this subcommittee or the full committee to tell us why they can't deliver this data to us sooner, like this summer, instead of later, like next summer. I think that's issue number 1. And issue number 2, and I ask AFGE to come back to us with a compelling answer. Does it make sense at a time of clinical shortages at the VA to have high-demand providers have 100% of their time devoted to official time? The answer may be yes. You made a great case from the perspective of the St. Cloud VA management that they didn't want to talk to someone 10% of the time and another person 13% of the time. They wanted to be able to go to you 100% of the time, and that ensured that they are more effective in delivering high-quality, timely care to veterans. And if AFGE can make a compelling case that it should, in some cases, be a physician who does that, then make that case to us. I want to start and end with what is best for veterans. And if you convince me that official time, 100% of official time in some cases, and 100% of the official time of a practicing physician is in the best interest of veterans, I'm going to go to the mat for official time under those circumstances. If you can't, then I'm going to be more open to changes to the system that we have today. So I think that's what we're all looking for as members of the committee, but I would caution my colleagues in rushing to any judgment or in passing a bill that even the VA, at least the representative from the VA today, cannot defend. Even though you say you support it, you also acknowledge that in the case of St. Cloud and in other areas, management has found value in 100% of time, and yet the VA's position is that they support the chairman's 50% cap. Those two things don't add up, and so we need to talk to someone or hear from someone who can make the case to us or support either one of those. So I still need some more information, Mr. Chairman, before I think I can make an informed decision on this bill, but I appreciate your effort in writing it and trying to address an issue that is of importance to the committee. And with that, I yield back.
Thank you, Mr. Ranking Member. Very good remarks. And I'm now going to yield to Mr. Rutherford, 5 minutes in addition for questions.
Thank you, Mr. Chairman. I would propose to the committee and the panel that the evidence that official time has failed in its stated mission of making things better at the VA, it's the case before us. It's why we're here. It's because official time and its purpose has failed, as in this written documentation by Mr. Wilcox is so eloquently put. Official time has failed the VA. It is failing our veterans every day. Because if your job through official time has been to make it better for our veterans, they have failed. Official time is not working, Mr. Chairman. It's evidenced by wait lines. It's evidenced by lack of service to our veterans who have earned that care. Official time has failed. The evidence is all through this testimony. We've seen it at our VA facilities. We hear it from our veterans. Official time has failed. I don't need any more information. I can look at the history of the VA and see that this has failed. And so, Mr. Chairman, I think the bill is absolutely necessary. Now, I don't put all the blame on the VA or the union even. The Federal Labor Relations Authority, if they're making decisions about who can be a union representative outside of the law, which is what I heard. I hear one person tell me there is no language that I'm going to be able to find that restricts those categories of employees that can or cannot be union representatives. But then I'm told that they make this decision that we can't restrict them. Mr. Chairman, I think we pass this legislation and make the Federal Labor Relations Authority adhere to it. But make no mistake about it, official union time has failed in its mission, because you sat there and said many times that the mission is to make it better at the VA. And it simply has not happened. And so I think we need to find a way to make it better, to get these classes of people particularly, is what I'm concerned about. When you have individuals, and Mr. Wilcox pointed out several of these cases, where they are supposed to be providing services to veterans, and they're not seeing a single patient. Not one. That's just not acceptable, Mr. Chairman. I yield back my time.
Thank you, Mr. Rutherford. Now yield 5 minutes again to Ranking Member Mr. Waltz.
Thank you, Mr. Chairman. In the most recent VFW poll of veterans who use the VA facilities, they have a 92% satisfaction rate. Cause and effect is always a very difficult thing to try and prove. There is other parts of this equation, like management and oversight, but I'll go to this. Mr. Wilcox, have you ever worked in the VA?
I have not worked for the VA. I've worked within the confines of a VA to meet with veterans as legal counsel and work with staff there on mental health issues.
Are you a veteran?
No, they wouldn't take me.
You ever been in a union?
No, sir.
All right. Is this correct, that your institution recommended granting emergency managers state of emergency power in the state of Michigan to override elected officials to toss out union contracts? Is that a position advocated by your organization?
We did advocate for the emergency manager law, and as his general oversight of a failing municipality, he did have that authority.
Would you recommend that for the VA?
If there is a serious enough situation that it warrants a takeover by governing officials, it would seem to be a possibility, but it's not something obviously I've thought about before.
Are you publicly funded?
Publicly funded?
Yeah.
No, sir.
Privately funded?
Privately funded.
Okay. Ms. Blumel, how many people did you say you represent in your bargaining units?
We have over 1,600 bargaining members.
How many people are on official time, 100% official time?
At St. Cloud VA,
Yes.
I have 2.
So there's 2 of you.
Yes.
How long will you do that? How did you get this position, if I could ask?
I was elected to this position 2 years ago, and I have 1 year left in my term by the bargaining members.
Okay, so your peers and the folks who work there, nurses, those combat veterans who work down there, they said, we want you to go speak to management for us.
That is correct.
Do you believe they asked you to do that to improve their own personal lives or enrich themselves? Or why did they think you wanted you to do that?
Because they felt that I had integrity. They felt that I would do the right thing, and I would stand up, listen to them when they had concerns, and do the right thing.
What will happen when your term is up?
What will happen? There's either 2 things. Either I will be reelected to be the union president, or I'll go back and be a nurse on the floor.
And either way, in your mind, you're serving veterans the best of your
Yes, I
ability.
am. I'm serving them either way.
Okay. So I would ask all of us this. There's 2 people representing 1,600 working with management at the St. Cloud VA. Had a management issue at the St. Cloud VA, had whistleblower situations. By the way, the St. Cloud VA is rated the highest in the VA system. Am I correct in that, in the star ratings?
That is correct. We're 5-star.
Okay. Would you say your institution is failing?
Our employees work very hard, so no, we're not failing.
And I noticed you hesitated on that. Is that because if you feel if one veteran's not served, then you consider that personal failure?
If a veteran is not served, yes, that is a failure.
Okay, but the data shows that, again, from the VFW on system-wide, St. Cloud even higher than that because we've had that polled after Mr. Emmer and I were up there. Very high satisfaction rate with what's happening there. You have new management. How's that working?
We have new management. It came over this summer, and we have a new director that will be coming aboard April 2nd. All of the staff are very excited, and as you know, we have over 409 of our employees who are veterans there, and they're excited about that too.
How long was the director position open before it was filled?
The past director left July 1st, and Mr. Black was just recently announced last week.
9 months then.
Yes.
Which is spectacularly fast in the VA HR system, I might add. Okay. I would just ask, and Mr. Chairman, I don't disagree with you on this, that we need to know these answers. And if we cannot provide the data, you're absolutely right to ask those questions. But I would end with 2. I would hope when you took Ms. Blumel to that town hall, you would also introduce her as a daughter and a mother of a veteran, and as someone who is serving in the VA, she could take those skills elsewhere, and I'm not disagreeing. And again, if anybody's abusing this, then we need to crack heads. But I think the assumption, how would each of us, if each day we had a different chief of staff giving us advice, going back and forth? So you can take 100%. I think you maybe ought to have the argument on this. If you're going to say we should have 4 at 25, what's the difference in that? You're making the assumption then that this one person is going to, just by going back in there, my example before was I never fired artillery, but I helped our unit fire artillery. So I just ask us to think about that. I don't disagree with wanting to get the data, but I do think assuming that union time is not helping veterans is a pretty big leap. I yield back.
Thank you, Mr. Ranking Member. And now we'll yield to Dr. Winstrup for 5 minutes of questions.
Yeah, thank you, Mr. Chairman. I apologize for getting here late, and so forgive me in some of my questioning, but I just am trying to get a picture of like what your day is like, and what do you do? Is it union activity? Is it taking care of veterans? Are you helping people take care of veterans? You mentioned, for example, making sure instruments are there. Did I hear you correctly?
That is correct.
Yeah. As a surgeon, that's a pretty important thing, making sure the instruments are there,
Yes, it
right,
is, sir.
before you go and do your surgery. But in our hospital, that's somebody's job. It's somebody's job. So you're saying if you're not there, the instruments may not be there?
What I'm saying is sometimes we have to relook at the instruments that are there because maybe they're not as efficient or they've caused an injury to an employee.
So are you really a supervisor? Are you a hospital supervisor to
No,
try and make
sir.
sure? That's what I'm trying to figure out because, people have a job. They have a responsibility. Their responsibility is to make sure, for example, that the instruments are there as requested, as needed for the case, and they deliver it. And there's no one else involved with that necessarily, unless there's a repeated problem. So I don't understand. So are you there to make sure that someone in the union is doing their job correctly? I don't get it. I don't understand why, and you use that as an example, and that's why I went to that.
Sure.
Because in our hospitals, there's a person responsible for having the instruments there.
Yes, that's someone.
And there isn't
yes.
someone 100% of the time trying to make sure that the instruments are there because that's somebody else's job. So are you there just for people who are not doing their job? Or is that your job? Do you put the instruments together? Do you deliver the instrument pack to the OR? Just help me here.
No, I don't. What I do is I make sure that, because our physicians are bargaining union, could be union or bargaining members, what I do is make sure they have the right instruments to help and take care of our veterans. And sometimes when we have an instrument that maybe is not as effective, or if there was an injury, I make sure that we get the right stuff. I get asked for opinion, or the employee will come to me and say, this isn't working, and I will go to management and we'll sit down and we'll have a conversation about what is the best, and we get to look at it. And no, I am not.
So it takes an interim person to do that?
Not all the time,
You mean the
sir.
surgeon can't say, hey, this instrument's
They
broken, I
do.
need a new one, can we put in for that, can I get that? They need another person. I'm just trying to figure out why you need to be part of that process. It seems to me that we're adding an extra step. I don't know, it's not very clear to me why you need to be in that role necessarily if people are doing their job. And if there is a problem, that they can handle it without having to go running to someone else and say, hey, we need a new instrument, can you be my voice? That person, it's their job. I just don't see that in other situations where that's taken place in private sector. So it's just kind of confusing to me in that regard. But I appreciate that you're there and you are trying to make sure that things get done. But it sounds to me like you're there in case someone isn't doing their job. Because I shudder to think that if you weren't there one day that they'd have to cancel a surgery or something like that because you weren't there, because it's already somebody else's job to get that done. And with that, I yield back. Thank you.
Thank you, Dr. Winstrup. I'm just going to ask if anybody else has any further questions or comments. I want to say again, thank you to the panelists, and appreciate your time and your thoughtful responses to our questions. You know, I'm new to the committee, and I've tried to listen and observe more than opine, but there's this theme, whether it's the IT, the first hearing we had on IT systems and millions of dollars in waste because of mismanagement there, or it's the Choice Act, or it's tracking union time. To me, the heart of the problem at the VA is a lack of accountability and the inability to manage the VA effectively, because I think one could argue we've thrown billions and billions of dollars, and in my opinion, some good money after bad because of a dysfunctional culture and system. And it's not dysfunctional people. I think you're a well-intended, good-hearted person, and I haven't met a VA employee yet that I don't think is a fine American and who deep down wants to serve veterans. But there is nobody who would run their business or run their nonprofit the way the VA runs their business. And there is, in my opinion, there is no way to have the culture and the lack of accountability and be able to provide excellent service to your customer, in this case, the VA. And I'm like my friend and colleague, Mr. Rutherford, I don't need any more evidence to know that somebody's spending 100% of their time on union activity when you have 45,000 vacancies and this awful wait lines and the lack of access to care. There's just no way somebody can convince me that that's reasonable and in the best interest of the taxpayer, let alone the veteran. We all want to serve our veterans. We all on this committee want them to receive the best care. I suspect also that everybody on the panel does, and we all know they deserve nothing less. I introduced this bill so that more individuals are focusing on this goal and focusing on the jobs that they were hired to do, as well as to bring greater transparency for the American taxpayer about where their tax dollars are going, especially if the money is being used for union activities, as opposed to paying for someone to do the job, again, the job that they were hired to do. I look forward to continue working with all stakeholders involved and my colleagues on this legislation going forward. And I now ask unanimous consent that the statement submitted by Mr. J. David Cox, National President of AFGE, be submitted in the record. Hearing no objection, so ordered. Finally, I now ask unanimous consent that all members have 5 legislative days in which to revise and extend their remarks and include any extraneous material on today's hearing. Without objection, so ordered. Thank you all again for being here today. This hearing is now adjourned.